Hey, welcome to Spin Legal on July 24th. And tonight our topic relates to the question of my landlord has given me an AGI. What can I do? So I'm Peter Giblett, and there's Angela Brown, and we're going to actually attempt to give you some answers for this. Right? So
An AGI is an above guideline increase for rent.
Yeah.
Your landlord would give you one of those.
And as you know, you get guideline increases. Usually you're given an N1 statement for the guideline increases on the anniversary of your rental, your rental change. And an above guideline increase can come at any time. Right.
So if they want to say, okay, we want to do a 3.5 increase or a 3.5 increase, this goes above the guideline increase. So if it's the guideline is 2%, then the 3.5%, it's a total is 5.5%.
Yeah. And essentially, we'll get to them anyway.
Yeah,
essentially, AGIs are actually limited in time as well. Okay.
Yeah.
Okay. So as I say, welcome to Spin Legal tonight on July 24th, and let's move into where we are. So you can contact us, Invictus Legal, at 905-688-5598. Or you can email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal. Our website is https weareinvictus.legal, as down there. Okay. And well, so here we go. Above guideline increases are essentially when a landlord makes an application for an increase that is gotten lost.
Yeah.
Okay. Makes an application to the LTB to actually allow a rent increase of more than the guideline amount. So for some or all of the rental units in a residential complex, right? So that's what an above guideline increase is.
Yeah.
Right.
You generally find them in large buildings, like apartment buildings, of multiple units, lots of units in them. Generally that happens, but it could also happen in smaller units like multiplex at 3 or 4 stories as well.
Yeah, and we've done what we did one.
Same rules. They have to play by the same rules.
And we did one for a landlord who had a 5-plex, if you remember, a few years ago. And, that was very successfully managed, etc. And we didn't have to go to the board for that one because there's a 5-plex.
It was done by consent.
Yeah, we got consent of the tenants. And for smaller complexes, it's typically a lot easier to get consent of tenants, or even to actually have I would mediate a session if tenants objected, and maybe you can negotiate and discuss in that mediation as to whether whether the percentage is actually valid or not, right?
Yeah, because this is what they do. Like what we did is when we did that negotiation for the increased rent for where the tenants consented eventually, this was done when the landlord was building adding some amenities that weren't there when the tenants started renting there. So this actually was a benefit.
Yeah, because he added covered parking spaces and nice places to sit.
Patio, a deck in the back, and a few things.
Yeah. Okay. So there are 3 reasons for an AGI. Firstly, what is called an excessive increase in municipal taxes, and we'll get to that. The second is increased operating costs because of security services that had to be installed. And third is capital expenditure work. So any rent increases are calculated in relation to the most recent rent rate being paid by the tenant. So if you've just been, if you just, if on July 1st you had your rent put up because it was the annual anniversary of you moving in, and your rent went up by $22.15, well, the AGI would apply to the the additional $22.15 that is now on your rent. Right, so it would go above that, and it would typically last for up to a 3-year period.
Yeah, because and then after that 3-year period is up, then it goes down to where the rent should have been if it was just guideline.
Yeah, and the new increases that you pay, you pay increases in the meantime. Those are all legal. So essentially, next year on July 1st, if the renewal date is July 1st, the if the rate of increase, let's say next year, is 2.1%, then the rent would be allowed to go up by 2.1%, and the AGI amount will go on top of that.
Yeah, and they can only increase the rent at 12 months past your time that you moved in.
Yeah.
So they can't have it given it to you at 6 months after you moved in. Okay, so these are things that, and that's just
So your normal rent increase appears on the anniversary of the date that you moved in.
So it has to be giving you 90 days notice with a form called an N1, okay, which they serve you, and it gives you the percentage increase, okay, which is comfort with the guideline and how much that represents with respect to your particular rent. And then it tells you how much rent you have to pay after that date when it starts taking effect.
Yeah, and as Angela said, it's an M1. The notice of rent increase, the landlord will tell you the amount of that increase, right?
Yeah, and this is rent that you have to pay. Okay, so this is not to do with the above guideline increase. This is just regular increases. Oh, Gary. Hi, Gary. How you do?
Thank you for coming along, Gary.
Yes, I love that.
Your piece. Okay,
never catching up on the Niagara talk shows.
All right. So if you decide to fight, please ensure that you save your money into a bank account. Save the AGI amount. So if they want you to pay an extra $30.62 per month, and you're deciding, no, I'm going to fight this one, put the $30.62 into a bank account and just stick it and stuff it away there until the decision is made, and we'll tell you why, right? We'll tell you why later on. So, okay, let's talk about what an above guideline rent increase is. We talked about guideline rent increases there, which is the annual increase that can happen.
Yeah, and then you have to pay, as long as they do give you proper notice and that it's within the guideline at maximum 12 months after you moved in, your anniversary. And the above guideline increase is a different thing. Okay? This allows the landlord to charge for more rent over and above the regular guideline increase that you're allowed to do, issued by the government. So
there are 3 reasons for that, as we just said before. And just repeating those 3 reasons here so that everybody understands. And let's go on to reason 1 then. Municipal taxes have jumped an extraordinary amount. Now, it's up to the board to determine what an extraordinary amount is. Case law has been, case law is odd on this one, because I looked up a few, and arguably an increase of 7.9%, which Niagara Falls had this year, could be argued to be extraordinary.
Yeah, but then again, it doesn't apply the same way to every single rental unit. Okay, some rental units, it may not be actually a 7.5% increase in the actual taxes. It's kind of a weird combination of it. Actually, what used to happen is actually the municipality would send a letter to the residences in indicating that the municipal taxes jumped X number of percentage points. And that and this could be used to take this just in case they're asking for an above guideline increase, and that it has jumped a percentage point. And these things are backed up by the municipality. So your landlord just can't come knocking on your door and say, "Oh, my taxes just went up there terrifically, so now I got to charge you this much more rent." No, it doesn't work that way. It has to go from your
part of that. And part of that is just because the city announces, or the local paper announces that rent the municipal taxes went up 7.9%, doesn't mean it happened to your particular rental unit. Your particular rental unit may have exceptions in them, or there might well be some some other things, or you may be in an area which actually is guaranteed to be zero tax rate because they want people to move in those areas. Depends exactly what your municipality is doing, and how that's managed.
And do you live in a new building? So there's a lot of different things that are factors. Like there's 1,000,001 factors, which in terms of tax assessment, we don't really want to get into a discussion about it, but you'll be notified by the municipality, or the landlord can get a letter from the municipality to indicate the tax rates, which would be considered extraordinary. Right?
And there is some case law on it. And if you come and speak with, us or a paralegal who deals with above guideline increases, they could tell you what is or isn't. And as I said, it would be dependent upon your individual circumstances. So I couldn't give specific advice on this show because, what was true in 2019 might not be true in 2024. And for example,
but the fact is, though, if the municipal taxes actually drop for a particular area, and this has happened, they have to drop the rent by a certain amount.
Yeah. Well, the other thing that does happen is the rate of inflation, by the way, is taken into consideration when the government of Ontario determines what the guideline increase rate is, which is why 2.5% was applied for the last couple of years, because the rate of inflation, although much higher than 2.5%, was taken into consideration that landlords had to pay more expenses in order to maintain their units, etc., and that tenants had to pay a portion of that increase. So therefore, the normal guidelines went up in order to account for some of that inflation. Obviously, when inflation's at 7 or 8%, you don't want that. You don't want to hurt the tenants. So typically, government's a bit more cautious when applying that.
They try to make that a mixed or a shared expense. That's why they look at that. Oh, hello, Robert, one of our perennial guests.
Yeah. Okay. And okay, so the second reason. If else on municipal taxes?
That's pretty well it. And these are things that would happen, and you would be notified. And if the reason for the jump is because of that, and you can also go to your city if, say, for instance, your landlord is challenging it and saying, "Oh, my taxes jumped 10%, and therefore I'm asking for an above guideline increase." You can actually go to the city and confirm that, and confirm exactly how much more taxes that landlord is paying compared to what he did before. And this is something that he would have to argue at the board level. If this is something that's challenged. Like a tenant can challenge any of these increases.
All right. Okay, so the second category that we had was of why you can apply an AGI is increased operating costs for security services. That's not, let's break this down. It is for security services. So these have been put in for a reason, because it's not just increased operating costs, because, hey, increased operating costs have already been taken care of in the normal guideline increase, because that's what the government's doing that balancing act for.
Let's
Right?
say you're in a neighborhood where there's been a lot of crime lately, and you're
Yeah.
in a building where people have gone in and painted graffiti all over the walls and been going through cars and stuff. And this is very concerning, because there's many cities. I think it's all over Ontario. I think we all share the same concerns. And then you live in a particularly bad area where this is happening. Then your landlord decides to be proactive. Maybe starts looking at having a locking gate, or having a security guard walk around for a little bit, or having a somebody coming in to have to check in on your residence, a concierge type of person. So there could be many ways of setting up security services to protect the residents and to protect the property. Okay?
But
There are
again,
condos have a lot of this, but that's usually included in condo fees. But
let's be absolutely clear about this. That isn't just because the landlord went around the side of the building and suddenly discovered, hey, we need to put a latch on this fence to make it a little bit more secure. Right? It has to be a significant change in the cost.
Significant
and they
change.
have to
The latch costs how much? $25 or something. Okay. But when you do something where there has to be a significant change, where they're really putting a lot of security up, setting up a gate when there was no gate, setting up something
has to be, exactly.
Yeah, there's a lot of different things that they can do, and very often they bring in someone, especially if you're renting from a building and and they're a large company. They usually have some resources that would come down and inspect the place.
One example that might well be for a security system is a fob-based system, where you have a car with a fob in your car, where when you approach the gate, it lifts up and lets you in.
Yep.
Right. Exactly. That's one example where the security system upgrade may be valid. But again, they would have to fill out an L5 application form. And within the L5 application form, they would have to detail those security costs within a Schedule 2 part of it. And that would all have to be detailed in precisely why those additional security costs for the building.
And the tenants would notice things. They would notice that they were giving notices, that they'd be given fobs and they have to sign them out.
Yeah.
And they'd be given specific permits, for example, for their vehicles, if they have to park in a specific place, so that you have a tenant permit. You know, there's different things that they have to do to protect things, so that they know that there's no unfamiliar cars walking in there and people walking around, respect the other ones.
Yeah, but again, if you could have an unfamiliar car parked in an unfamiliar space, and that would essentially happen. So you've changed your car. You've changed not only you changed the shape of your car, because you used to buy salons and now you buy an ATV or something. You know, that sort of thing might be a dramatic change in the type of car that you've got. And obviously, you don't want somebody towing it, but equally well, what you're doing is you put a tag on the car to say, yes, this is valid for this building.
Yeah, exactly. And this is something you just buy a new car or something, and or you get a new car. Somebody just says, okay, like, I got a new car now, this belongs to me, and then you show them the registration, then they just give you the new tag.
Yeah, and actually, in fact, you probably sell the old car at the same time, so you you probably keep the tag, but you just have to inform the building. But security, it's increased security, so that's a pretty serious thing, right? So
exactly, because this is going to be very important these days, because I'm hearing about it. I go on different forums, and we're talking about, like, people in different neighborhoods of the city. They're talking about, this guy's going around, he's going in through cars and he's taking things from cars, or they're porch pirates going around. And So there's a lot of different things like that in just regular neighborhoods.
That's where my Amazon package went. Yeah. Yeah,
Oh yes,
we
all you
know.
gotta
Yeah.
do is get one of those camera things, and then you'll at least take a picture of that porch pirate.
Yeah.
Yeah,
Okay.
but these are things that are very good, and that's another reason why the landlord would do it. He'd have to itemize the costs, how much it is, what it is, and the tenants would also be getting some notice of what the security upgrades would be and what
Yep.
they need to do to benefit.
Yep. Okay. And the third reason is what is called capital expenditure. This is work that has already been completed on the residential unit. And there is a matter of what is capital expenditure. And for example, in the case of TNL 68214-15, which is an LTB review case, they stated an extraordinary capital expenditure is an extraordinary or significant repair or renovation where the expected benefit from that repair or renovation lasts at least 5 years. However, that said, I include this one. There is other case law that denies expenditure that gives benefit for 10 years as being capital expenditure, and they stated that to be just maintenance.
Capital expenditure is like you're putting something new in the building or you're upgrading that building.
Yeah.
Okay, it's not like the roof is leaking. Oh, the landlord's got to fix the roof, and then he puts in an AGI.
Yeah, that's not typically capital expenditure. If you spend $1 million fixing the roof because there's a leak in the roof, that's maintenance, not a capital
Yep,
expenditure.
because your landlord's supposed to be keeping an eye on that so it doesn't come into becoming $1 million expense.
Okay, from the viewpoint of the tenant, the majority of arguments about the landlord's expenditure will result in whether the charge is just maintenance or really is capital expenditure. And let's give you so essentially in that regard, the L5 application from the landlord must be detailed, as defined above, and each Schedule 2 form should be accompanied by receipts, contracts, inspection reports, and other relevant documents. So this is, to be very clear, if your AGI was landing on the doorstep today on the 24th of July 2024, all of the expenditure and all of the work must have been finished already.
Yeah.
So given it probably takes them 3 months to prepare and get ready to file the L5 application with the board. So therefore, typically what would happen is all of the work will have been completed by, let's say, the end of April, right? And if they're basically saying this will be complete by the end of by Labor Day, that does not count. That is not relevant for an AGI.
Yeah,
Right?
they have to have everything that's already been complete. So
Yeah.
if you were in a building and you start to see maintenance people coming around, and they appear to be working on balconies, fixing things, or going in, retiling floors, doing different work around the building, somebody on the roof fixing things. In the future, there will be an AGI applied for.
Maybe an AGI.
Yeah.
Right. The difference is, it's a question about the difference between maintenance and capital expenditure. And typically what will happen is a landlord, particularly those big landlords, like to kind of get recover the costs of their expenditure through an AGI. And the trouble is that it comes down to what is, how, whether you can challenge them or not. And
Yeah.
at the end of the day, tenants can challenge an AGI.
Challenge any AGI.
Absolutely.
It doesn't mean you will win, but
Yeah.
there are grounds that we have to look at. We have to review the complete L5 application and all of its components to see what we can argue about, and and to try to fight against their proposal, the work that has been done, and whether this is maintenance or whether it's capital. And
Yeah.
it's a very complicated procedure. We have done them,
Yeah.
and generally they result in some type of mediated settlement. If it has to go to a full hearing, that could be a pretty complicated situation. But having a mediated settlement is good. There are some of us that only do AGIs, and there are some of us like ourselves. We've done quite a few of them, in addition to other work in the landlord tenant board. But
Okay. Yeah. Go on.
yeah, yeah. Generally, when you're looking at a tenants association, like there could be, say, there could be 200 people in the building, and maybe there's about 100 of them that just got upset over this proposed AGI, and then they can hire us as a group, and we challenge. We
Yeah.
just challenge it through their tenant association, and saying that this is not appropriate and so forth, and we take instruction from their leadership.
And I would say also to you, bit of advice if you're a tenant and you've just received an AGI or an L5, a notice of an AGI from your landlord. And there's a number of tenants out there, because you'll know better than I will about who's talking in the building. Number 50, number 501 wants a rent strike over this one. You know, essentially what you need to do in that regard is to, I would say, go seek legal advice.
Yeah,
um
advice. Even
Come
if you're
together.
planning a rent strike,
Yeah.
seek legal advice, because there's a lot of consequences that can happen out of that too.
Yeah, and go speak with a paralegal and who has experience challenging the AGIs. Companies like Invictus Legal, we basically do these kind of AG. We've done several of these AGIs, and the point about them is you can negotiate right from the outset, potentially. But one of the questions here is that, for example, if you're talking about 100 tenants in a building would have put up $50 each. That's more than adequate usually to pay legal fees for an AGI challenge.
Yeah, because that's generally what we do if we're going to do a group challenge on
Yeah.
something like that, and then we work with the leadership of the tenants group to gather all the concerns and from each of the tenants, and we put that forward. There's also some very worthwhile things too. If say if they really did piss poor maintenance of the building, and you always had leaky roof, it was always drafty in the winter, things like that, but they still expect you to pay for all the replacement of their windows. You know, those kinds of questions could be introduced too. So there's a lot of flexibility there, what we can challenge and what we can't. These are things that we've done. Every building is different. Every situation is different. Even buildings run by the same company. Each of the buildings that are run by the same company are different.
Yeah.
Because they might have different ages, different structures, different history. So this is there. And yes, you can challenge that. And in terms of being a landlord, there's a lot of stuff that you need to do if you are a landlord out there and you want to get a rent increase in your building. And there's perfectly legitimate reasons, as we discussed, why that you might want to get get above guideline increase.
Yeah.
And we discuss the reasons why. And what we do is we help you go through the steps and walk you through the steps to make sure that everything is done by the letter, because it has to be done exactly by the letter. And
Yeah.
this has to be done, and things have to be made available. Anybody can look at the rent challenge. They can ask the board, saying we're looking at the AGI called whatever application it is, the application number. We can get the disc. We can have that sent to us, and then we can look at it, and any tenant can look at that. And generally, what happens is the tenant association representatives would be looking at it and sharing it with their legal rep to go through it step by step, and what should be put in.
And as I say, if you share the cost amongst, say, I don't know, let's say you've got 500 tenants in the building, and you share the cost amongst 100, 150 tenants, that can typically help you have a fund to fight the AGI.
It gives you a legal fund that you
Yeah,
can
it gives you a
use.
legal fund in order to go through the whole process of the AGI,
Yep.
and it's much better to do that than to come for one tenant to come to us and say, "Hey, I want to hire you to fight my AGI," because
Yeah.
it's a lot more expensive in that regard,
Yeah.
right?
And unfortunately, legal clinics can't do this because legal clinics are there for those people who qualify for legal aid.
Yeah,
Okay, because some tenants may qualify for legal aid while others may not. So
yeah.
there's a whole issue with that, and then there may also be conflicts.
Well, and even if, as I said, even if you've got 100 people and they each put up $50, a person who could qualify for legal aid could probably put up $50.
Yeah, absolutely. We've had that. We've had
Yeah,
that before where people pass the hat
yeah.
and then at the end of the day we just agreed to do it and that's it. Right?
Okay.
So
All
yeah.
right. And okay, the role of the legal representative is actually to break down each of the claimed costs in terms of this application and the tenants. So there's a complete cost assessment of the entire application. And as I say, a lot of it is about whether it's a valid use of an AGI, for example, as I said, capital expenditure versus maintenance,
Mm.
and or whether this is a security upgrade or not. And we wholly understand why security is an important issue, right? So those things all have to be taken into consideration, and to a large extent, it's you, the actual tenant in the building, it's going to, what I got the other one time was, yeah, they put these new fancy lights in, but all they've really done was put a new cover on and screwed a new lamp in there, right? It's an LED rather than a conventional light.
Yeah. Or all they did is a paint job in the lobby and they want us to pay a
Yeah,
3%
yeah.
increase.
Well, so let's put a couple of examples. So here's the thing: putting a new swimming pool into a rental complex where there was not one before, that's probably going to be accepted as a capital expenditure,
Absolutely, because this
right?
is something new
It-
and it's an amenity that many
yeah,
tenants would enjoy.
yeah. And in fact, actually,
Requires maintenance.
in that circumstance, it could be a thing that they actually may be validly allowed to increase your rent by a certain amount for anyway,
Yeah. And
right?
this is
Um,
something that sometimes if you live in a large complex, sometimes the landlord will go around and meet with tenants and ask them for things. He says, is there something else that you would like in this building that's not already here?
yeah,
Okay. Try to get some ideas from people what they would like to see happen. Okay. Maybe they want a party room. Maybe they want to have a
well, yeah,
pool. Have a pool. Maybe they want to have some saunas or a gym and stuff. So there's a lot of different things tenants
right,
might give some inputs, and then the landlords take it back and see how they can make it happen. Right?
yeah.
But it's going to result in an AGI.
Okay, the next one is by contrast, though, maintenance of an old swimming pool that is being brought back to life can be challenged, even if it is 10 years since the pool was last operated,
Yeah,
right?
yeah.
Because, because it would have to be something significantly different to the pool
Yeah.
to be considered a capital expenditure.
Mhm.
Just
At a
fixing
water park.
just fixing it, putting new pipe work in, etc., is not necessarily capital expenditure,
Yeah.
right? The may well, I'm not being an expert. There are certainly some, you could do some maintenance to old pools that could be considered capital expenditure, where you're doing dramatically changing how the pool functions. But you would actually have to assess that, and you may even need expert advice on that,
Hmm.
right?
So these,
Um, And
yeah, this is where the landlord would often bring in engineers and to review it, and because you're going to have to do it. If there's
yeah,
going to be some things like that, they have to bring in
and
engineers and have drawings and put permits in, and
yeah.
it's a lot of work. Or at least the bureaucrats make it into a lot of work.
But again, once the claim is out there that, hey, that tatty old swimming pool is now we put capital expenditure into the swimming pool, as a tenant, you may actually need some advice from an expert, a swimming pool expert, that says, is this really a capital expenditure? Give us your viewpoint upon it.
Yeah, yeah, because that could be part of the challenge on that. Like we can bring in a swimming pool expert, people who've built pools for ages and who've put them in grounds all over the place, and we can ask them. I says, okay, if they can go in and do a report on this, what was done, exactly what was done, and they can review the paperwork concerning the pool, and they could say, this is just fixing up an old pool and bringing it back to life. That's it.
Yeah, yeah. And that may persuade the board that is mere maintenance and not a capital expenditure, right? Okay, so once a tenant's paperwork is filed, and that's the important point about what I was saying with all of these, is you assess each of the points within the landlord application. You break them down, and you say, I accept this point to be capital expenditure.
Yeah.
The tenants deny, point 3 to
Yeah,
be
we
capital
go we
expenditure.
go point by point by
Yeah,
point,
yeah,
okay? Because we want
and
to make sure that we are crossing our T's, dotting our I's,
yeah.
so that our challenge is going to be credible. And
And at
based
the
on
end
that,
of the day,
some
at
of
the
it
end of
will be capital, and there may be still some rent increase that they're entitled to,
yeah.
but maybe not all of it.
Yeah, and for example, you used the roof example earlier on. Leaky roof. All they've done was spend $1 million on fixing a leaky roof, right? Well, that's maintenance. Don't care how much it is; it's still maintenance.
And you have to
Right?
replace your roof over a certain period of time. There's part in the regulations that talk about maintenance regulations and maintenance guidelines. It
Yeah,
talks about how long a life certain items have.
yeah,
Okay, like if they're going into all the units and they're putting in hardwood floors when there was no hardwood floors before, it was all this crappy linoleum or whatever it is that goes into some of these buildings, and then they're putting all hardwood floors. That might be something good because hardwood floors has something positive. There's positive benefit with that. So there's a lot. Yeah.
yeah. I was going to say, there's positive. How would you call that? Positive karma comes out of hardwood floors,
Yeah.
wouldn't it?
And a lot of people nowadays, people are moving away from these shag rugs and these
Yeah,
wall-to-wall carpeting, and they're moving more towards area rugs
yeah,
and
yeah,
hardwood floors. So it's a very much of a thing, and it also adds to value to the building, which is one of the things too that needs to be contrasted.
yeah,
Because the value of the building only benefits the investors, while some of the things that they put in place also benefit the tenants that are in there.
yeah. Oh
That
yeah,
they get to live with
absolutely.
a new fridge, get to live with new flooring, granite cupboards, granite, yeah, all that stuff. So I mean, that's pretty good.
Yeah. Okay. All right. And essentially, so having broken it down, you kind of file that paperwork to say, hey, Mr. Landlord, here's our response, the tenant response to the AGI. At some point, there will become what is called an adjudicative case
Educative case
conference,
conference.
right? And that may well then be talking about what happens. Can we resolve the situation? So they're looking at mediating the situation, and the mediator will have read all of the submissions. So, if whether you're a tenant association making a 300-page submission, whether you're the landlord making a 500-page submission, or whether you are a sole tenant making a 20-page submission. They will have read all of those submissions, and they will have understood. And ironically, also, don't believe for a second that the landlord's representative hasn't done an analysis upon the tenant's legal position either, right?
Yeah.
Because they will often go away, because they know they're going to put in some stuff. They kind of, well, we want to get this $1 million we spent on roofing back. But when the tenants come back and say, no, 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 that is not a superior roof, that is just a fix to the current roof, then they might walk back down from that. They might kind of assess and they go, yeah, okay, we probably can't get away with that.
Yeah, and many times the landlord's own legal representative would look and say, oh, there's a lot of blowback on this.
Yeah.
Right? They will talk to the landlord. It says, is there some areas where we can give? I said, the tenants gave us some facts here. Hey, can we look at this? Right?
Yeah.
And then we go to a mediation. And many times they have it. There's a few lawyers in Toronto that we've come up against, and they often do represent landlords on AGIs, and very good to work with. They will mediate, and they try to work things out. Okay? So it's a process that you really have to know what you're doing. You can't just go in there and try to just shoot numbers around and see what you can do. No, you really have to know why, and why we are not accepting that as a capital expenditure and so forth. Okay, so these things have to be properly researched, and that's why legal representation is essential.
Yeah, so essentially, one example that I have is that the landlord, in their original L5, put out that they wanted a 3% rise above the base for all of the units mentioned in the application. And when it came down to the actual mediation, they actually changed their tune and they said, we're going to change, and we're putting, actually our proposal now is that we're looking for a 2.2% rise. And the tenants, having spoken with a number of tenants, we put in we put in a counter suggestion that it should be 1.2%, and we settled at just over 2. Right, I think it was 2.01. I think it was net. But the point being is that you have a landlord rep that can listen to common sense, and that's an important point.
Exactly. Okay, and this is very important, and this is why it's very important to have your legal representative, especially someone who has some experience going through this. Not every paralegal has gone through this.
This is very complex
because people have contacted us. So what we've done is we've worked with them and we worked through the process. And one of the first jobs Peter actually did when he came into the office is I handed him a big pile of $500-page document. I said, this is an AGI request. I said, go through it and tell me what's wrong with it.
and my first task was, okay, what's the rules about AGIs? Yeah. we probably did that for 5 minutes in paralegal school.
Yep, and this is one of the things that when you have somebody experienced, and we've had others since.
The interesting thing is about this is, on a few years later, I saw this person put into a paralegal forum and said, how do I do an AGI for 100 tenants in a building? And somebody turned around and said to them, I've been a paralegal for 10 years and I wouldn't touch it with a barge pole.
Yep, exactly.
And I turned around and said, hey, I was fresh out of paralegal school when I did my first AGI, right?
I know I'm the guilty party. You gave him the work.
The point being is that with a paralegal, you need somebody with the skills and understanding of a paralegal in order that they can actually go and break down what the law is, and it's largely about what the law is.
Yeah, standards, various things.
The questions of maintenance versus capital expenditure, or whether a security requirement is valid, is actually a matter of law. You might think it's a matter of, yes, evidentiary wise, it may well be a matter of what a particular expert, what one expert might say against another, but primarily it's a matter of law. And there are for each type of improvement that's been done, there are laws associated with it. So you have to go find those laws, apply those laws to your situation in order to say this is a valid capital expenditure or this is mere maintenance.
Yeah, there's a lot of things like natural life of a product, like carpeting, flooring,
Yeah.
Various things like that are all known and are documented. And these things that they come in, like say if something would last is supposed to last 15 years, and this is 15 years old, and they need to replace it, that's maintenance. Okay, it's not doing capital expenditures, unless they're going to be giving you marble floors or something. Oh yeah, I'd love to live in a place with marble.
Actually, the one that I remember on one of the applications that I did is they put in all of the flower beds, they put brand new what's it called, the red bark, right? Red bark is no way that was going to be maintenance, nothing going to be anything but maintenance.
Yeah. So what did they do? Like put gold in them or something? Like...
I don't know, but hey,
I would be looking for the gold.
but in fact, actually, the red bark is unlikely to last more than 2 or 3 years.
Yeah, exactly. These are things that they do, and landscaping is basically maintenance.
Yeah.
You generally have a landscaper who goes in and does work.
Well,
and keeps the grass cut.
I disagree in some respects.
Something that's different. Like if they start adding things that are different and really attractive, you get a gazebo here, and you get a nice little outdoor spot, little fire pit, different things like that wasn't there before. There might be something there.
Yeah, exactly. That's how I was going to say. That was the kind of one difference. Say they acquired a new plot of land, which was an old, which in its prior life was the site of an old eyesore barn. And having pulled the old eyesore barn down, now they put up a nice gazebo, nice seating area, nice pleasant walkway around that area.
Mm-hmm.
That may well therefore be valid capital expenditure.
Yeah, exactly.
Yeah.
Like that, because there has to be showing there's a tenant benefit.
Yeah.
Okay, to the new capital expenditures, not just something that's going to get the owners more money when they sell the building.
Yeah.
So these are things that we work on, because it's a matter of critical thinking and having the critical analysis.
Okay, so we come to the point when we must discuss that rent money you saved. So we said save the rent money, and there'd be because essentially you would have to pay for the increase. Once a solution is found, whether that's a negotiated solution or the board issues an order, the tenants may be expected to pay for that AGI in a lump sum. In one particular case, what had happened, it was 4 years between the original application made by the landlord and the time when the board hearing took place. And I understand that they are quicker now, but that was 4 years due to COVID. So essentially what happened in that scenario is that the company, the landlord, asked for the payments to be made in 90 days. So that's why you need to have saved the money, right? Don't go spending it down the casino. Don't go doing anything funny. Save the money, keep it just in case. But for example, if you're saving it, if you're saving $52.96, which amounts to 3% of your rent, right? And you're asked to pay 2.0%. You've made a saving. You've already now got some money. You can buy something, buy a Christmas present
buy something nice for yourself. Yeah,
exactly.
Yeah. And this is very important because if you don't pay the increase, they could go after you for arrears.
For non-payment of rent.
Yeah, for non-payment. So you have to be very, very conscientious of that.
Yeah, absolutely. And the last thing you should do is, as I said right at the very beginning, when people say, "Oh, we're going on rent strike," talk to get legal advice before you do
Talk to
anything
a
like that.
legal advisor if especially if you're part of a tenant association
Yeah,
and they decide that they're going to go on a rent strike. I mean, sometimes a rent strike will do things, but you have to be extremely careful doing one of those things
yeah.
because of some of the risks.
And not, yeah, and an AGI isn't a reason for going on a rent strike.
Yeah, usually
All right.
there's a lot of other more serious issues that
Yeah.
generally put
Okay.
people out to take those types of risks.
All right, and I'm going to remind everybody that if you need to contact Invictus Legal, you can do so at 905-688-5598, or you can email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal, and feel free to go look at our website, https weareinvictus.legal, and the link is down there in one of the early comments. Okay.
Yeah, and if you want to talk about something or you want us to talk about a specific topic of interest to you, hey, please let us know. Please write to us, call us, or send it to our website or something, or through the Facebook page that you may be watching us from, and say, I would like to hear a discussion on such and such. And we take all of this into consideration when we plan our shows. Our shows are once a week, around 6:15ish or whatever, whenever we start. Yeah.
Yeah.
And then we try to get them in as much as we can, and we try to listen to our audience, what we have, and sometimes we have questions coming in that we will answer, okay, to the best of our ability. If we can't answer anything very specific, like if you're trying to write us and asking about a very specific legal situation, we can't address that. Okay, but however, if you want us to address a specific legal situation, you have to call us and come in for an appointment, and we can talk and do a consultation. So this is very important that we do this. There's nothing in this show or in any of our other shows that we've had that constitute legal advice. Okay, because legal advice is something that's given to you specifically, that to your specific situation. Okay, because sure, I mean, there's a lot of things that come in, like all of our AGI applications and our AGI files that we've worked on were very different from one another. They all have very different features and issues that we address with them. And this is why talking to a paralegal or a lawyer when something like this comes up, it's essential that you go and speak to them, as opposed to saying, "Oh, well, you said on your show that," or "I heard on Spin Legal that." No, no. Basically, this is just a commentary discussion to get people interested in some of the legal topics that we raise. Again.
All right. And thank you for watching Spin Legal today. It's been a pleasure having you, and come back next Wednesday, 6:30ish, right?
Yes.
And we'll have a nice discussion about something else next week.
Yeah.
All right.
If you have a suggestion, pop it in